Our next speaker is Kevin Baumgardner with the Seattle firm of Corr, Cronin, Michelson, Baumgardner, and Preece. Kevin's a trial lawyer. He's tried numerous cases in state and federal courts in Washington and Alaska, including labor arbitrations and administrative cases in multiple jurisdictions. His client list includes a Olympic medalist and a Nobel Prize winner, but his expertise that he has developed and that which he's about to talk about today is in whistleblower claims, in which he has represented clients in commercial aviation and the nuclear industry. He has been recognized as a litigation star by Benchmark Litigation, and in his spare time, Kevin is an avid equestrian. He is the former president of the United States Eventing Association, which is the American governing body for the Olympic equestrian sport. Galloping up here is Kevin Baumgardner.
Thank you very much, and good morning. Let's just start by defining what the real issue here is, and it's a cultural issue as well as a legal issue. The whistleblower is lionized in contemporary culture, and I'd ask you, is there anyone here who doesn't know any of these four people, who they are? And I'd also ask, does anyone not know who James Spader is, who played Daniel Ellsberg, or Meryl Streep, or Julia Roberts? I'm sure Edward Snowden will have a silver screen counterpart soon. It'll probably be Jack Nicholson, judging from what we've seen the last couple of days. But again, therein lies the danger for the company that is a target of whistleblower claims. And added to that is the role of the media. Really, you will not get a break when someone who is a self-proclaimed whistleblower brings a claim against you under one of the statutes, against your company. And in fact, has anyone ever seen disgruntled underperforming employee brings whistleblower claim? You won't see that as a headline. Instead, here are the headlines you'll see. These are all from the last few months, and they're indicative of the way that the decision is made by the media to validate these people as genuine whistleblowers. And in terms of the actual statutes, they've been proliferating at an almost exponential pace. These are some of the statutes that I've worked with, and there are many others, in almost every industry you could imagine. And you know, I think everyone's aware that when Congress deals with regulating a new industry, it's almost de rigueur to put in a whistleblower protection statute. And in fact, one of the most recent ones, if your company contracts with the government, you should be very aware of this. This is the National Defense Authorization Act of 2013, and for government contracts or modifications to government contracts that were made after July 2nd of 2013, this whistleblower statute is in place, and it has stronger pro-claimant provisions than most whistleblower statutes. I mean, in fact, it has a 3-year statute of limitations, whereas many have 180 days. And it also has some other protections. So be aware of that. The materials discuss that in some detail. And whistleblower protection laws that I've dealt with, and I think many of you and your companies have probably, unfortunately, had experience with these, they have a lot of aspects that really stack the deck against the employer. The materiality of the alleged adverse impacts is often negligible. In other words, if you give an employee a slap on the wrist letter saying, you know, don't do this again, you know, don't swear at your supervisor again, that can be enough if that person claims to have engaged in protected activity to sustain through summary judgment a whistleblower claim. The low standards of causation are a real problem too, a contributing factor for most of these. I've dealt with the Air 21 statute and the Energy Reorganization Act quite a bit, and instead of saying the predominant factor or a 51% factor, a contributing factor. I mean, how many people really in an HR department who have some, you know, total pain in the ass employee aren't thinking somewhere in the back of their mind, 10%, I'm glad to get rid of this asshole, right? And that becomes enough. So it's a problem, and of course we know in this day and age that thought somewhere gets translated into an email. So be aware of that. Obviously there's a one-way cost and attorney's fees recovery. And the administrative adjudication, I just want to mention that. Many of these statutes, you go into an administrative process that can be a tremendous crapshoot. You may, in fact, have an initial investigation done by someone from OSHA who deals with, paint cans falling off of ladders and is suddenly dealing with technical concerns in the nuclear or the aviation industry or Sarbanes-Oxley, very, very complex financial matters, and they don't know what they're doing often. And it's scary because what they do is they try to connect the dots. Did this person who was working as a graveyard shift mechanic fixing airplanes, did this person ever bring up a safety concern? Well, I think probably someone who's fixing the engine on an airplane and says, do I think I should do this or that? He's probably dealing with something that's airworthiness. So of course he did. But is that something that really should sustain these claims? Be aware. And this is one of the other scary aspects of these claims, the frequent filer. And this is not my term. This is a term actually used by the people who adjudicate these claims because they roll their eyes a little bit at them too. But this fellow, Syed Hassan, he has filed no fewer than 17 separate lawsuits because after being terminated and bringing an unsuccessful, unsustainable whistleblower claim, he kept reapplying to the same company, the same series of companies, and when he's denied employment, he brings a new claim, and eventually the Seventh Circuit sanctioned him for these nonsensical claims, but he's brought some further claims that have been sustained on summary judgment. He hasn't been able to be knocked out on summary judgment. So again, it's in the playbook of the support groups for these types of claims. So the question is, what do you do? That's the problem. How do you deal with it? And the first thing you do is you make sure that your company has a robust compliance program. That is a different CLE. I'm not going to deal with that. That is a whole half a day unto itself, but that is very important. Having said that, you are not going to avoid these claims if you're in certain industries. And what do you do when a claim comes up? And I can't emphasize this enough. Carpe diem, hire the experienced, skillful trial lawyer with experience in whistleblower claims immediately. Don't hire a law firm, hire a lawyer. I mean, we've heard that this morning. It's not law firms that win cases, it's lawyers. It's not law firms that create the bond with you and work well with in-house counsel and with the company as their client. And then you get going immediately because whistleblower cases, some of them are valid. I mean, let's make that an upfront point, but they're often brought by employees who have an axe to grind, and there's something else behind them. And they take on a life of their own. If you don't get out in front of them with someone doing an aggressive, attorney-client privileged, litigation-directed investigation, you're going to be in trouble. So the game plan is, again, carpe diem, seize the day early. Claimants' lawyers, I've found, I think this is true, a lot of people have experience in related areas, also in product liability cases. I think claimants' lawyers will neglect the upfront preparation. That's what I've found. So what you do is you get on the case first, and you frame the narrative. The question really is, whose motivation? We've talked about the motivation of the HR person or whoever's making the termination or other job decision. How about the motivation of the so-called whistleblower? What is the motivation of this person who is claiming to have a safety concern or a financial disclosure concern in mind? And you've got to dig. And that's got to be the story. Everyone knows that trials are battles of competing narratives. Frame that narrative and seize it. And focusing on the legal elements of the claim is very important too. I've won cases, whistleblower cases, not on the merits, but simply on the legal elements because the plaintiff's lawyer was too lazy to instruct his or her client on the elements and they were open to summary judgment after deposition. Locking in the case terminology early, I can't emphasize that enough. You need to focus on a glossary of terms that you want to force into the case narrative, and often that the other side will acquiesce in if they don't realize the significance of them early. I mean, an example would be if a whistleblower would like to make their concern a safety concern, how about making it a technical issue? Safety concern, sexy. Technical issue, boring. How about you do that? And you will find early on that that will be acquiesced in more times than not. I call this actually the rule of 10 degrees. If you're starting the case and you're in San Diego at the point there, and you just move the case terminology 10 degrees as you go forward, by the time you get to trial, one of those boats will be in Hong Kong, one will be in Tokyo. You'll be a long way apart. So you have to do that early. The other point, everyone always talks about discovery against the company. In whistleblower cases, you need to take aggressive discovery against the claimant. And, you know, personal files, Twitter, Facebook, emails, obviously. Often you control the emails, and there's such a thin line between what are company-directed emails and personal emails. So many whistleblowers who tend to have kind of self-inflated egos anyway, or messianic complexes in some cases, will use their company email for all kinds of personal reasons. And you will find candid comments. If you're truly dealing with someone who is bringing a claim that does not have validity, you'll sometimes find comments like, I intend to retire on this case. I'm bringing this, not because I really believe in it, but because I need the money and I can't stand working here anymore. That type of thing. Communications with friends and relatives. You immediately need to start preparation of a witness deposition file. And again, if you are in-house counsel, the one thing you need to do is demand that your trial lawyer, the person who's going to be up front at trial, be involved in this process and eventually be taking that key claimant's deposition. And of course, you have to be very careful in reviewing the key company witnesses' documents at the outset and gathering your own documents for production, because you're going to get very comprehensive discovery requests in this day and age. And the integrity of the document collection review process is so important. I think that you all know the authorities that are out there. Almost all document collection ultimately will be subject probably to the federal discovery rules or like rules. So do it right from the beginning. And find out if there's a real problem. Find the bad documents, put them into context. I mean, if there really is a true problem and someone was terminated for illegitimate means, I mean, maybe it's time to pivot to settlement mode. I mean, that could be the case, but you need to do that early. One thing you should do, too, I should just mention is, and I think was mentioned in one of the earlier comments today, if you have someone who's leaving the company, A, an exit interview is a great thing to do. B, turn off the access of that person to company electronic files, their company computer immediately, and preserve that computer. Because once people decide they're a whistleblower, they're going to start stealing documents left and right. Obviously, interviewing the key company managers. And what you want to do, part of this, that third bullet point, is developing a psychological profile of the claimant. I mean, really, you want to know what makes this person tick, because that, again, is going to help you in framing this narrative. You need to do it before their deposition so you know how to approach the deposition. Always videotape the deposition. This is trial testimony. It's about credibility. And again, the trial lawyer, if this is the person who's going to stand up for you in court, that's the person who should take the deposition. Discovery really is a misnomer. It's all about trial testimony. And don't be afraid to not only use the deposition to tell the story through the claimant, but also to ask the ultimate questions. In other words, go ahead and ask the deponent, challenge them and ask them in a nice way, not in a way that you're, it's obvious that their answer should be no. But if they want to sink their own case, give them the opportunity to do so and let them talk. Give them the rope to create a problem for their own case. This is an example of an Air 21, a whistleblower case that I took, where again, through, most of the time, honey is better than vinegar in depositions. I established a rapport with this guy. He was a nice guy, really, who was the plaintiff. And I got him to say, at the end of the day, so you're not claiming that basically the company ever did anything to compromise safety, are you? And he said, oh, no, of course I'm not. Because really he didn't believe that in his heart of hearts. It was effectively the end of the case. Defending company witness depositions. This is something that I think is neglected, particularly in whistleblower cases, because again, there's often been some bad blood between the company, between the often the manager of the person who's been terminated or has had some sort of a bad job action, and the actual plaintiff. And you need to get past that. You need to budget the time. You need to, this lower bullet point, you need to conduct mock video deposition questioning. Everyone knows television is a cool medium. You need to show people how bad they look on TV. I mean, how many people here have actually been in a witness situation, a mock witness situation, or maybe even a real one, and then seen yourself on TV, and we're all horrified by it. I mean, even if we're doing well, we aren't actually what we think we are, and it does show how much practice makes perfect there. I do want to mention just briefly the special challenge of the CEO deposition. CEOs are a different breed. They, really have the willingness sometimes to do significant damage to their own case simply to twit their general counsel or to simply because they think they're smarter than everyone in the room. And often they need the most coaching because they're so used to dealing with analysts on the phone, giving glib answers. They're so used to kind of bullshitting their way out of any situation. And everyone knows the story of Bill Gates and David Boies. Bill Gates thought, I'm the smartest person in the room, and he's had a pretty good challenger there in David Boies, but he may well have been the smartest person in the room, but the result was disastrous. What he needed, if anyone really had the standing to do it, was an in-house lawyer to say, you're going to get killed, and let's take you through this, and we're going to change the way you're going to present yourself, at least for that one day. So be aware of that. When you have a very strong personality with that executive mentality, you have to know it, you have to deal with it in preparation. Final thing I want to mention is media strategy. And my experience with whistleblower cases, I've done, 15 or 20 of them, and many of them high profile, is you can't win in the media. The media will try to eviscerate you, and they want a white hat and a black hat. We heard about high concept yesterday. What's more high concept than white hat, black hat? That's why Meryl Streep stars in these movies. It really is. And so do think twice about appearing on, 60 Minutes. Because we had, one of my clients one time wanted to appear on Rachel Maddow. And I was like, no, A, she's smarter than you and she'll kill you. And B, she's for the other side. No. And C, she has editorial control. Never give editorial control to someone in that situation. So always think ahead and have a multidisciplinary strategy, which should involve counsel as well as the media people, the key executives. Everyone should be on the same page. And don't swing for the fences with the media, because again, you're going to lose in the media, or you're at least not going to be satisfied with the result. But if you're smart about it, you can win at trial. And even with some judges, you can win at summary judgment. That's the key. These cases are winnable. That's the story. So good luck with them. And my final message to you is ride horses. Thank you.